First of all, Attorney Opera, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the Public Defender's Office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would.
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr. Brooks, I presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, that evidence have. But you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to that. What do you mean by it's no surprise to me that it exists? That was not the issue. The issue was, how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue State can make an offer of proof on that, because obviously they marked it as an exhibit.
Well, with all respect, Your Honor, you're mischaracterizing what I said, and the record needs to be clear. The issue that I raised was, how does this, at the last minute, out of the blue, become an exhibit? That was the issue. Go ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social media.
There's nothing that.
He didn't say what it was.
Sir, stop interrupting.
No.
We have to make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me.
To be quiet?
Stop rolling your eyes at me. Stop
I'm
mumbling.
I'm looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it, and I've made note of it.
I'm looking at you. Okay, so are you asking me to be quiet, or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
I'm gonna take that
and
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination, so the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about,
There's a reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No.
But
What I've observed is
for her, listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they've been doing that the whole time. I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we have cameras. That's what the cameras are for.
Let's refocus our attention on what we're here for, and that's
this
trial.
Then I take that as.
Do you have anything you want to put on the record?
I'm putting it on the record if I get a chance.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not. She just said she just made it an exhibit. It was not an exhibit before she made it one.
So do you have some legal basis, sir, for your position? Because I'm not
What do I need legal basis for when she just admitted on the record that she just made this exhibit up right now?
Didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't implying that by saying that she could pull anything out of her suitcase.
So that's a figure of speech.
Okay, so what is it implying to? What would that be implying to?
As attorney,
how would anyone in my position?
Because you're not providing me with any legal basis.
I didn't even finish. You told me that I can make the record. I'm attempting to make the record.
Sir, as it relates to the video and my decision to admit it,
I just said that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I wouldn't get to that if I didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you open the door to the playing of that video.
We're not talking about opening no doors.
And the video was previously provided to you during discovery.
We're not talking about opening no doors. We're talking about being fair.
There's absolutely no prejudice to you.
Your Honor,
in terms of surprise.
With all due respect, if I had done that,
I am going to move on.
If I had done that, it would have been a big thing.
I'm advising you.
Are you asking me?
I'm advising you, sir.
Oh, okay.
I'm advising you to sit down and be quiet. And if you interrupt me again, you are on notice that you will forfeit your right to be present in this trial.
So you're holding me in contempt.
Mr. Brooks.
For the entire trial? Did you say the entire trial?
I never said any such thing.
You said for the trial. So what do you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to come at me.
I don't consent to being called that name.
You continue to fight with me.
I'm not fighting with you.
You are being disrespectful.
I'm not fighting with you. I'm not.
I'm going to give you one last opportunity to sit down and be quiet so I can make a finding as it relates to other things.
Are you asking?
I don't
to
need
do
to
that?
ask, I'm telling you.
Fuck me. Holy shit. This guy. I
Thank
swear
you.
to Christ. I can't
There were
wait till he
two
goes to
other
general
issues
population.
that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing it
Mr. Brooks, I'm only gonna ask you one more time, and if you don't
I'm saying,
answer it
if I don't
correctly,
understand,
then I
if I
will
don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like,
yes or
I don't
no.
like your tone and the way you're talking to me. I don't
Brooks.
appreciate it.
Sit out. I don't care if you don't like my
I'm
tone.
not gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to
now.
each other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
gonna give
to
him that
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're in
I know?
recess, 15 minutes
How do
from
I
now.
know
Thank you,
what I'm
everyone.
supposed to answer if I don't understand? And I don't agree to a stop.
Oh my god, what a fucking shit show. And we are not even to lunch yet. Let's see what we get next.
Let me do that again. We are back on the record. State versus Brooks appearances are as they were before.
I don't consent to being called that name, for the record.
You've said it about a million times. You think we
Are
haven't
there
heard
any
it? Shut the fuck up.
issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
No, Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has, so I believe we are good on that.
I had one question
sure.
about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a
Otherwise-
certified bail form.
No, I'm asking.
Oh.
I'm asking Mr. Brooks.
Oh,
So,
sorry.
that was the second of the two bail bonds. Do you have a recollection of whether it was received?
I don't.
All right. Then
I
what was?
know I objected to it.
I know you objected when it was, I
Big
think,
fucking surprise.
displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there gonna be any other exhibits that we need to tidy up the record in front of the jury with?
Judge,
I
it's
don't
hot.
think so. I know at one point, someone caught that we moved, it was either exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record, so I don't know,
So I may have just
I
had a
think you
misspeak.
misspoke.
yeah.
But
Do you have any recollection of that, sir?
recollection of what?
Do you know what, was that, what the state just put on the record? Do you know what, was that, what witness that was?
That was, Detective Casey.
Look at that.
I think he's falling apart.
175 was the screenshot taken from the video. I know I have a note that it was received and published. And you believe I may have just referenced it by the wrong name?
I thought it was 178, I thought you referenced it by the wrong number. So it's either 175, 175 was referenced as 165, or 178 was referenced as, one.
I know the, okay.
178 was the video.
Oh, that was the
video.
most recent one, okay.
On his eyes.
When the
He's
jury
basically
comes
a
back in.
child. He's
What's
a
the
child.
request then as it relates to when the jury comes back in?
Your Honor, I just,
His mom is probably his grandma.
there's two different ways to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all.
He's probably broke as fuck too. And he's probably been taking everything he can get from her along the way. What a piece of shit. Fucking burn in hell, dude.
Been offered and admitted into evidence, and the court's agreeing, because we've just agreed that those are, your records are the same as my records, or we can claim that we're shown has a.
Position on,
I'm objected to him being admitted at all.
well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No, it
the
don't.
fact that I've already ruled on the
Definitely.
admissibility is not something I'm gonna revisit.
What I gotta say
Hold on,
definitely
that door is, all right, it's, sometimes that door upstairs malfunctions.
You don't know anything.
All right, I didn't hear
And
the
you
last part
talk
of what
about
you said.
things like you know what
what
you
I have
talked
to say about anything definitely
What you
doesn't
say
matter.
really doesn't matter.
I take huge objection with that, sir.
It's true.
And it,
Wait,
that
what'd
may
he
be
say?
your
Hang on,
perception,
what'd he say?
but
Hang
that is
on.
absolutely,
It's
What'd
true.
he say?
and
I have to say about anything definitely doesn't matter.
said,
What I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And it, that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break, You and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings, because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made, is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on.
This attitude right here.
Now, with respect to,
that's my.
I want to also address
9-year-old. That's how she acts. Like
exhibits.
That's what she does.
And the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was frankly to assist the court and my clerk in keeping track. Most trials, the normal course of action is, as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal, we're not quite there yet, that as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement, unless a judge orders it, that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, despite your questions, and I frankly kept it out. The door could have been open, moved on from there. Example, things happen. Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson.
No shit.
And I frankly kept it out, despite your questions. So, with that, I want to bring the jury back out. I will ask the state, I'll simply just ask the state, are there any anything additional the state's offering by way of testimony or exhibits, you can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony.
Matter jurisdiction that you're pulling up?
Oh, here we go.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
When would that be proven for the
Sir,
record?
please don't interrupt me. I need to focus on what I'm doing.
I'm not interrupting you. I'm just asking a question.
All right. I'm not going to be addressing that.
So would it be
don't
proven
interrupt me right now. I'm trying to do something on my computer.
Would it be
and I need to
proven on the
focus.
record?
Important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement,
Want to see him on the stand. Let's do it. Let's go.
Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not.
What's the significance of that?
So that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right.
Ignoring.
And the jury will be advised one way
Stop!
or the other.
Close the book! Put it down! And look at me! God damn it! We are not playing this fucking game!
Okay, let's bring the jury out then, and we can kind of tidy up the record, and then we'll break for lunch.
Judge, may I remove that exhibit, please?
I think they're right there, so let me just take it.
All right, let's have
Jury already coming out.
I'll just stick
Okay, so go
All
ahead
right,
and sit it back
jury.
down. Thank you. Subject matter jurisdiction still hasn't been proven for the record, John.
He waited till they started coming out, so he started bringing it up.
Should be proven at some point.
Where do you think you are? That's subject matter jurisdiction. You are being held in a place being tried for your crimes. That is subject matter jurisdiction!
Thank you, everyone. Please be seated. All right, then I'll turn to the state. Any additional evidence at this time?
The state has no additional evidence, Your Honor. May we make a record as to the exhibits?
Go ahead, please.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number, or it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
The most recent testimony, with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over. Exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo.
Thank you. Sorry, I had a scribble on my pad. And 175.
And 13 and 14. Those are the outliers. I apologize.
I believe those were received as well, but if I didn't state
I think
it,
they was already received.
I appreciate that. I just want to have any additional
State rests.
hour, at least. From you at this time, given the state is now rested.
What you mean?
I'm asking you the question. Do you have any requests at this time now that the state has rested?
What requests pertaining to what exactly?
I'll ask the question one more time. Do you have any requests to make at this time now that the state has rested?
I don't understand what you mean by that. That's why I'm trying to get clarification.
I'm not going to give you legal advice. I'm simply asking the question. Do you have any requests to make at this time now that the state has rested?
She ain't playing around no more.
I don't know what I'm supposed to say to that. I don't understand.
She's done with your games, dude.
Would that be pertaining to?
I can't give you legal advice, sir. I'm just asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state has rested?
I don't understand.
All right, the other thing I want to do when the jury comes back out is, you will recall I read instruction 101 at the very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that. I think it's appropriate given
Let's go!
Yeah! Opening statement until the start of his case.
Oh, be cold.
With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Go ahead.
Yeah, of course you do.
Do I get to present exhibits and stuff like that too and admit them into evidence?
Too bad.
At what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer for
Give me an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings. Everything
Which
that I filed.
filings, sir?
Every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to.
Oh,
You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm being
filings.
general based
You don't
on what
know
I've seen thus far.
what the
So,
fuck you talking about, dude?
are you
Not at
talking
all.
about
You don't
during
know
your
the
opening
first thing.
statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I've filed a number of documents. I think that's on the
Well,
record
without
that I
knowing what
filed.
you're referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They would only be
Because you're not
relevant
a
to
lawyer.
obviously the matter.
Yeah.
They wouldn't be
Sir,
relevant to anything
I
else.
can't answer that anymore. We're gonna take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
So I'm not allowed to offer anything in the evidence.
For the record, I never said that. We are in recess.
So I'm trying to understand.
I intend to have the jury brought out. I presume you're ready to go?
Having a slight issue finding certain.
Can you sit up, because I'm not hearing you very well, so that the microphone picks you up, please?
I'm having a slight issue locating some of the files that I need. That's what I was trying to say.
All right.
The locate are calling pertains directly to the witnesses that I will be calling. Pertains directly to locate the files that I'm attempting to locate are pertains directly to the witnesses that I will be calling. I'm not sure what witnesses are here today.
Well, let's do this. I'd like you to at least do your opening statement, bring the jury and do that. I'll give you an opportunity to look again. I can have the state write down who's here. I believe it's based on what you told them, and then if there's still something you need at that.
So I'm clear, I didn't give a specific order in who I will be called,
Sure, I'll
Who
have the
would be-
state, sorry,
who would be called.
who's here
That's what I was trying to get at.
before you make your opening statement.
Well, so I know if they're not here, then essentially I can't call them.
Let's address that after I'll have the state write down who they know to be here now or who's coming this afternoon, because there might have been people here this morning. I believe they're still here, but I'll bring the jury out for your opening statement. I presume you're going to give one.
I am.
Okay. My prior written decision stands. I will not be addressing that further. I'll have the jury brought out, okay?
Subject matter jurisdiction.
My prior
knew
written decision
that's what you
stands. I will not be
Stupid
addressing that
motherfucker.
further. Your objection is noted, and I will be continuing with the trial.
Is it verified proof for the record?
Sir, I don't believe I need to do
you
that.
don't know
or
what
that
you're
the state needs to do that as well. I
about.
believe your statement about that is a misstatement of the law, and I do not intend to pursue that further.
Can you show me lawful law that says that?
I gave you a written decision. I have done that.
Can you show me lawful law that verifies that
Sir,
for the record?
I gave you a written decision. You
That
can,
I accepted for value in return for
and
value.
that's
because
how I'm going to answer that.
it
So
was
let's
not verified proof.
Here it goes. Here we go.
We still
Fireworks.
aren't.
Sir, there is no requirement in the law that the state or the court establish that. So
Actually,
your
there
objection
is.
is noted.
Actually, there is, Your Honor. Subject matter jurisdiction has
Sir,
to be
please.
proven for the record. Has
It does
to be
not.
proven. Has to be proven. You know that just as well as
Mr. Brooks,
you know that.
please do not make statements that mischaracterize the law
You know it has to be proven
or that
for the
impugn the
record.
integrity of this
You
court
know it has to be proven
and the
on the
proceedings
record.
here.
You know
The
it
jury
has
is
to be proven.
advised to disregard the statements that Mr. Brooks is making regarding subject matter jurisdiction. They are not evidence, and you are to disregard them.
You're not presented as evidence. Just has yet to be proven for the record.
The jury will disregard the incorrect statements of the law that Mr. Brooks is stating.
Where's
I
lawful law
can't
that is
believe
incorrect?
Mr. Brooks,
Still
please.
going
I'm
here.
going to read one
The
instruction.
entire
Thank you,
time.
everyone. Please be seated.
She's gonna get them
The
pulled
defendant
right
will now
back
make
out
an opening statement.
during this
The
opening.
purpose of an opening statement is to give the defendant an opportunity to tell you what he expects the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. With that, go ahead, sir.
Obviously, I don't have any rehearsed or well prepared speech, so I'm just gonna speak from the heart. I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember, is that there's always two sides to every story. And for so long now, roughly a year,
For so long, a year.
there's only truly been one side told of this story. And I've sat back and watched from countless narratives that's been put out there,
Your narrative is you ran down.
the way this incident has been portrayed at times.
It's portrayed as you running down a parade of people.
Finally, everyone getting a chance to get the full story.
And slow everything down as much as possible.
You won't hear me try to argue facts. The fact is, this incident was tragic. Very tragic. That's not lost on me. Facts are that there's still a lot of people healing. A lot of families healing. On both sides.
There's some people that are not healing at all, you know?
And when I'm confident that
After you ran.
the evidence will show, sorry, I'm getting a little emotional. But I'm confident that the evidence will show is that this incident was not planned. This incident was not intentional. And this incident was never even thought about. It's easy to I'm sorry. Give me a second.
You're watching in your mind all those people flying off the front of that fucking car. You piece of shit. I can't wait till you get the general population. Oh, you're gonna cry a lot there, buddy.
I think it's easy to look at the magnitude of something like this and
You're
form
gonna rest your
opinions.
life, buddy. I hope you get the death penalty. But then again, up there in fucking Waukesha,
I
they
think
probably don't do that.
it's easy to disregard a lot of factors.
Mm-hmm.
And I think in reference to what I stated earlier, it's easy to forget the other side of the coin.
Oh, you're a victim. I was sad, so I hit the
There's been
pedal.
a lot of suffering involved in this incident. A lot.
Wait, what'd you say?
Obviously, obviously, with the families, a lot of suffering involved in this incident. A lot.
There we go. That you caused.
Obviously, with the families,
I guess tiny tissue. Pobrecito.
with the community.
Pobrecito. Wah. And you're just making it worse by disrupting the whole fucking system. You ran people down. Go down, dude.
The alleged defendant's
Guilty.
family as well. There's
Just
been a lot
plead
of
guilty.
suffering.
Plead guilty. Take whatever deal the fucking DA gives you. You piece of shit.
A lot
Fuck
of
off.
misunderstanding.
Go to hell and die. Sorry for you.
And
You ain't got no fucking self-control, you piece of shit. Ain't no way I'm letting you.
I just want you to keep in mind,
Peace, motherfucker. Bye-bye.
everything that will be presented
I can't
in
wait
its
till...
totality. Keep in
till-
mind.
I can't wait till you get to the general population to do it.
The power that you
Have a
have.
good time with your ass, ain't they? Kangaroo. You try to play kangaroo court, they're gonna play kangaroo court on your ass. Eat shit and die.
I believe.
I believe. I believe. Yeah, I bet you do. I bet you
That
do. Oh, you're gonna.
should escape
Gonna
your
believe something.
knowledge.
You're gonna believe something new. Coming up pretty soon, son. Bye.
This has been a long process for everybody.
Oh, really? It's been a long process. You think so? You think you contributed to that, you piece of shit? Sack sucking. Fuck you, man. Go eat shit in prison. Fuck you.
And what I believe is
What I believe.
when it's time for you to make your decision.
It's time for you to make a decision. Yeah, that I'm not the piece of shit that they have proved me to
Believe
be.
it.
You going away.
And I pray that
Right. You're
it's the
done.
right decision.
You're out, dude. You're done. Fuck you. No remorse. Ugh.
That all the factors are weighed.
All of that. Subject jurisdiction. Subject jurisdiction. Subject jurisdiction. Also, your tie looks like shit. Learn to tie a fucking tie. Also,
Been a lot of
cuffs under order. Man, fucking learn to wear a fucking
words
suit.
thrown out there
Get the fuck out of here.
about the alleged. A lot of speculation, a lot of ridicule.
Yeah, because you ran over fucking 60 goddamn people, you jackass. Fuck you.
Words like demon. Words like monster.
Pobrecito. Yeah, give me the ugly cry. Give me the ugly cry. This is my daughter. This is my daughter. She's
You
10.
know,
Oh,
a lot of the
11
time
years.
I've been before you, you've
Close to
seen
fucking
me
up.
with I've had my reasons for that,
You had your reasons for
but
what?
I feel now is the time to.
Fuck you.
It's
Now
important
it's
that
it's time for me to fry.
you see me for who I am.
Yeah, who you are is a piece of shit that's gonna
No mask.
fry. Goodbye.
Who I am.
Goodbye.
I think this is the moment for that.
That's probably a good time. Yeah, if you're a piece of shit, you know, it's probably time for you to die. You killed multiple people? Yeah, you're going down, son. You're gonna fry all your stupid arguments that trying to delay everything aren't gonna work, and this trial is gonna be over. Yep, you're
I
looking.
pray that your
You see it, don't you? You see it. The end. Oh,
eyes and ears remain as open as possible.
you ain't gonna win nothing with all your stupid, fucking disruptive arguments. In fact, you're probably just making it worse for yourself.
You understand that you alone decide this case, this matter.
yeah, you really made it pretty easy, haven't you, Sonny
The
boy?
power is in your hands.
Sonny Jim,
All of you.
good luck. What? What?
To determine for yourselves what truth is. Thank you.
I'm from the sea too.
Thank you, sir.
No concern. Oh.
And do we have their writing materials available? All right. Thank you.
He's literally just gonna sit there
Mr.
and
Brooks, you
cry.
ready to call your first, would be your second witness, actually.
Yeah, but she pulled the jury out because he was inconsolable. Oh, he's so sad with all the people that he ran over and his end of his life. I mean, that's how it works, right? Play stupid games, win stupid prizes.
That you were looking, if you could perhaps just confer with him over
Oh, you
which
did not
witnesses
take
were,
off your
are,
glasses because you got
which
emotional
witness
for this piece
told to
of
come
shit.
back out sooner.
This, obviously, this woman has children and plays the same game with her children. They're probably spoiled too. She's spoiled. Objection! Spoiling the defendant. Spoiling the defendant. It's not fair. It's you're coddling him.
Mr. Brooks, have you found what you were looking for?
I found my mommy.
We're just gonna work off the list of the people who's here.
Okay.
Oh boy, they're gonna make him cry.
You know who you're gonna call
in
first?
prison.
We'll have that person ready.
Ooh,
Okay.
buddy.
You wanna let us know so that the state can assist with that?
He doesn't want to let the state assist with anything. He wants to.
Otherwise, you can just call when we
Just-
are in front of the jury. So have the jury brought out.
I can't wait.
Some
I
of
can't
them
wait.
are downstairs and some of them are out here, so it's fine. It just will take a few minutes if they're over in the main courthouse.
Okay. Why don't you tell the state the first witness to make sure they're right outside the courtroom, sir?
Most likely.
Oh, he's calling us first.
Bertram. It's like
Please, sir. That's all.
this. I kind of.
Who do you want to call first? And we'll.
Sorry.
That's okay.
He's been crying.
Apparently,
This-
this
you
list
know.
is who's here. I'm guessing.
Not you.
Your dumbass didn't want to cooperate with the state who was trying to help you.
Is there someone you expected to be on the list that is not?
Kinda.
Do you want to make a record of that? Do you want me to address it in any way?
No. Not right now.
I just didn't know what I was doing, and I want to complicate the process.
All right, well, then I'm going to instruct the jury to
By
come out,
being-
and then you can call your first witness.
I would love to be able to contact the guy that sits behind him every day and like personally pay him for like a hobbling or something like that. Man, I just hurt this guy. Hurt this guy. You're making problems. You know what? I'm paying for this. I pay for this. Darrell Brooks, I'm paying for this. I pay for your fucking. Ah! You disparage me with your frivolous fucking nonsense in a goddamn fucking court ordained situation. Fuck you. Fuck you. Fuck you. Give me my money back. Oh, class action lawsuit against Darrell Brooks. Here we go.
Thank you, everyone. Please be seated. Or you may call your first witness. Actually, your second witness.
The defense would like to call the plaintiff, state of Wisconsin, to the stand.
What?
Object.
The objection is noted. It is sustained. Call your next witness, please.
You had to know. You had to know.
Not relevant.
Mm-mm.
And you haven't named a person to go along with it.
The subpoena was accepted, Your Honor.
I'll take the issue up outside the presence of the jury if necessary. Call your next witness, please.
Well, I would like to make an oral change motion to dismiss for failure to appear by the plaintiff and for failure to state a claim from which relief can be granted.
I will take that up outside the presence of the jury.
Lee,
Next
were you gonna
witness,
screw it?
please.
You fucking
So is the state not present?
Mr. Brooks, I'm not gonna address that any further. While the jury's present, I'll take that up outside their presence. Call your next witness, please.
The defense calls Nicholas Kirby.
All right. Nicholas Kirby. Is that a witness who's in the hallway, do we know?
I don't believe in the hallway, but we will.
Have him brought over, Your Honor.
All right, thank you. It'll be just a moment or two
I
while
hope
we
he
wait for
takes
that
the
witness
stand.
to come
Please,
into the courtroom.
please take the stand yourself. I want to see you on the stand. Please. I think that would be the best. Also, we're filing a class action lawsuit against Darrell Brooks for wasting our tax money. Oh, Jesus Christ. This is your witness. You don't have your questions ready for your witness? Jesus fuck. What the fuck is... Dude. What the fuck, man? Come on. I know you're getting this from jail, but you decided to do this for yourself? You... Fuck off. Lazy piece of shit. Make another fucking rap video.
Sir, would you please make your way to the witness stand? It is up one riser to my right.
Fuck,
When
I
you get there,
would
please
love
remain
to see
standing.
you take the stand,
Raise
you
your
piece
right
of shit.
hand, and my clerk Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. Please have a seat. Is to state each. Go ahead.
First name Nicholas, last name Kirby.
Right. Thank you. Go ahead, sir. Your witness.
Good afternoon, Mr. Kirby. How are you today?
I'm here.
What do you do for a living?
Mostly temp work.
Do you recall the events of November 21st of 2021?
All too well.
Do you see how he stands? Like he wants to look like he's a lawyer and stuff like that. It's like stupid, man. Stop watching TV, you stupid fuck.
And what were you doing that day?
What were
What
you
time
doing?
of the day?
What were you doing that day? Let me ask you.
3 o'clock-ish.
3 o'clock-ish. Around 3 o'clock-ish, I was walking with Corey around Waukesha. Earlier, well, yeah.
And made reference to walking with Corey. Who is Corey?
Corey is a friend of Miss Patterson's.
And would it be fair to say that it's also a friend of yours?
I hate that.
Mutual friend, yes.
I hate that he says, would it be fair? Every question, like almost every question he asks, he tries to say, would it be fair to say, he's trying to sound like a lawyer, but he has no idea what law really fucking entails. He has no concept. He says, he's like, and why they're coddling him. It upsets me. Because I think that this is going to ruin law for lawyers. For people who are dedicated to the law. I do worry sometimes about the infiltration of the next generation being so highly socialist, communistic, and trying to integrate their personal biases into law. I do worry about those kind of things. But at the same time, you can't let people do this to our law system. You can't let them do this. And the judge, as smoking hot as she is, and as matronly, beautiful, patient. I mean, she is showing so many good characteristics, and probably just to make sure that he goes down as hard as he has to go. It's hard to watch. The whole thing is hard to watch.
In reference to Corey?
Yes.
Oh. And what were you doing?
Walking around Waukesha, she was waiting for Miss Patterson to get done meeting with Mr. Brooks. You.
At 3 o'clock?
Around 3 o'clock-ish. Around that time, I had advised her not to go meet with Mr. Brooks.
You made reference to Mr. Brooks. Who's that?
That would be you.
And why would you say it would be you? That's you.
Because that's your name.
And you were privy to that information at the time?
I was privy to the information about you about a week prior to this incident.
About a week prior. And during your walking around, what were you doing with Corey?
Walking, like literally walking. We went from one store to walking around downtown after Erica told us she was going to be going to meet with Mr. Brooks. That would be you. I had advised her not to do it because it was a bad idea, and I was in fear for her safety.
You're Fuck you. Fuck.
You made reference to going from one store to another. Which stores are you referencing?
Dollar General and Speedway.
Did you go anywhere else?
No.
Did you ever go to a park?
No.
Yeah, come on, Darrell. What else you're laying at?
You made reference to knowing about Brooks a week prior to these events, you said?
I didn't know everything about him. Miss Patterson had showed me his rap sheet, if you will, and a picture of him, and that was about it. I had heard prior
I'm going to stop the witness unless you want him to go there, not to discuss what may or may not be conduct of Mr. Brooks prior to November 21 of 2021. With that understanding, go ahead and ask the next question.
You made reference to a picture you were shown?
Just a photograph with a rap sheet behind it.
And at some point, did you and your mutual friend Corey meet up with Miss Patterson?
Yes.
Do you recall where that was?
Corey and I were in the Dollar General area of Waukesha, which is between East and Broadway Street. We were walking towards, or away from Dollar General, towards where Erica had said that she was being assaulted and attacked.
And do you recall where that area was?
Yes.
Where was that area?
On White Rock Avenue, right across from White Rock Elementary, in front of the red apartments across from that area.
Red apartments.
Yes.
Do you know what those apartments are called?
I do not know the name. I'm guessing they're called White Rock Apartments.
And do you know if there's a park in that immediate vicinity?
There is a park there named Frame Park, yes.
Did you ever go to Frame Park?
No. We were in that area near the park where the elementary school is and the apartments are.
About what time did you and your mutual friend Corey meet up with Miss Patterson?
Miss Patterson called me and said that she was...
About what time was the question? About what
And
time?
I'm getting to that.
I'll direct the witness answer his question specifically. What time?
Honestly, around what time the parade started. I would have to say like dusk. I honestly don't wear a watch, so sorry, I don't remember the time. But if I had to put it at a time, I'd probably say about 4:35-ish.